Before we begin, remember that this video is for educational purposes only and isn't legal advice. Case summaries are meant to support your study, not replace reading the full case. This is one of those landmark cases that shapes how lawyers think. If you've ever wondered whether a professional can be held accountable for a mistake that costs you money, this case explanation is for you. We break down RHW v. Jones 2002, a landmark decision on professional negligence, so you can understand the limits of duty, how courts decide causation, and what it means for clients and lawyers. Let's dive in. Alright, let's start with the real-world problem. This is the part that helps you understand what is actually going on before you jump to conclusions about liability. Imagine you hire a solicitor to handle a property purchase. You trust them to spot any legal issues. In RHW v. Jones, the claimant engaged the defendant's solicitor for exactly that. The solicitor failed to advise on a restrictive covenant that later caused a significant drop in the property's value. This case shows how a simple oversight can lead to big financial consequences. Solicitor-client relationships automatically create a duty of care. But what exactly does that duty entail? Here, the court examined whether the solicitor's duty extended to protecting the client from economic loss due to a hidden covenant. It's a classic example of how professional duties are defined not just by contract, but by tort law. The solicitor breached his duty by failing to conduct a proper search or warn the client. The loss was clear. The property was worth less because of the covenant. But was the loss within the scope of the duty? That's the key question the court had to answer. Many clients misunderstand that not every mistake leads to liability. The loss may want to be the kind the duty was meant to prevent. Now that we know the facts, let's get into the legal meat. This is where the arguments on both sides can teach you a lot about how courts think. The central issue was whether the solicitor's duty of care extended to protecting the client from this specific type of economic loss. In negligence, duty isn't infinite. Courts consider the relationship, foreseeability of harm, and whether it's fair, just, and reasonable to impose liability. This case pushed the boundaries of what a solicitor may want to guard against. The claimant argued that because the solicitor was hired to handle the conveyancing, it was reasonable to expect them to uncover any encumbrances affecting the property's value. They said the solicitor should have known that a restrictive covenant could drastically reduce marketability and price. So, the failure directly caused the loss. The solicitor countered that their duty was limited to completing the transaction safely, not to guaranteeing the property's investment value. They argued the covenant was a matter of public record, and the client could have discovered it themselves. Moreover, the loss was purely economic and not a consequence of physical damage, which traditionally has a narrower recovery. The court had to balance previous decisions like Caparo v. Dickman, which set out the three-stage test for duty, and Headley-Byrne v. Heller on negligent misstatement. Policy considerations included whether opening the floodgates would make solicitors overly cautious and slow down transactions. Quick reminder, this is a study summary, not legal advice. Always read the full judgment for complete context and nuance. So how did the court resolve this? Let's break down the reasoning step by step, because this is where you see legal principles in action. The House of Lords held in favor of the claimant, finding the solicitor liable. They ruled that when a solicitor undertakes a specific task, like a property search, they assume responsibility for all consequences that flow from a negligent failure to perform it properly, even if those consequences are economic. Applying Caparo, the court found proximity. The solicitor-client relationship is inherently proximate. The harm, financial loss from a hidden defect, was foreseeable. Imposing liability was fair, just, and reasonable because solicitors are insured and clients rely heavily on their expertise. On causation, the but-for test was satisfied, but for the solicitor's failure, the client would have either renegotiated or walked away. The court also used the common-sense approach. The solicitor's breach was a substantial factor. They rejected arguments that the client's own failure to check records broke the chain. Damages were calculated as the difference between the price paid and the actual value with the covenant, plus consequential losses. This case reinforces that in professional negligence, the normal measure is to put the client in the position they would have been in had the duty been performed properly. Now let's extract the legal rule from this case and see how it applies in other professional contexts. This is the part that helps you predict outcomes. The rule: a professional who undertakes a specific task owes a duty of care to perform it with reasonable skill and care, and will be liable for economic loss directly resulting from a breach, where there's reliance, proximity, and it's fair, just, and reasonable to impose liability. This rule isn't just for solicitors. It applies to accountants giving tax advice, architects designing a building floor, or financial advisors mismanaging a portfolio. The common thread is that the professional holds themselves out as having expertise and the client relies on it for a specific purpose. But there are limits. If the loss is too remote or the client failed to mitigate, recovery may be reduced. Also, disclaimer clauses can limit or exclude liability, though they're subject to statutory controls like the Unfair Contract Terms Act. And if the client is a sophisticated business with equal knowledge, duty may be lessened. To spot a potential professional negligence claim, ask: was a duty explicitly undertaken? Was the advice or service specific to my transaction? Did I rely on it? Was the loss a direct result? If yes, you might have a case, but always consult a specialist solicitor, as limitation periods apply. Finally, let's cover what law students and practitioners often get wrong about this case, and how to use it effectively in your legal reasoning. One common mistake is thinking that a professional owes a duty to protect clients from any financial harm. RHW v. Jones doesn't go that far. The duty is tied to the specific task undertaken. If a solicitor wasn't hired to advise on investment value, there's no liability for market changes. Understanding this scope prevents overstating precedent. This case is a perfect illustration of the Caparo three-stage test: proximity, foreseeability, and fairness. In exams and practice, walking through Caparo with RHW's facts shows deep understanding. Remember, the court also considered assumption of responsibility and reliance, which are key in economic loss cases. When facing a problem question, use RHW v. Jones to argue for liability where a professional failed to uncover a hidden defect in a property or business deal. Distinguish it if the loss wasn't from the specific task. Also, note its place in the line of cases after Headley-Burn and before later Supreme Court clarifications. Refer to this case whenever dealing with solicitors' negligence in conveyancing, or more broadly, any professional failing to spot a legal or technical flaw that causes economic loss. But remember, it's not authority for personal injury or physical damage. Those follow different rules. Keep it in your toolkit for pure economic loss scenarios. That's the practical version of what matters most. The big idea is to understand the problem, compare the right details, and avoid rushing into an expensive decision without context. If this helped, like and subscribe for more case breakdowns and legal education from LawConquer. Remember, this is a summary for study purposes. Always read the full case. Thanks for watching. Remember, this is educational only. Read the full case and consult your course materials. Subscribe for more case summaries.